Thank you very much, Mr. Speaker. It's my pleasure to rise on this important debate today, and I'll be dividing my time with my friend from Calgary, Signal Hill. But I want to take a moment to thank someone who has used his time in Parliament to advocate for an important issue that will actually help all Canadians, and that's the Member of Parliament from Central Okanagan, Similkameen Nicola, who, since his time here, has helped Canadians and helped businesses, particularly small businesses in the Okanagan he represents, but across the country, to sell more product within their own country. These are world-class in the case of wines and his Free My Wine and Free My Grapes initiative that are world-class selling around the world, but there's restrictions about selling it one province over, Mr. Speaker. So his advocacy over his years in Parliament, expanding the personal use exemption, allowing Canadians this choice that really should have been provided decades ago, has been something that shows that a passionate and knowledgeable Member of Parliament can accomplish great things, and we're here debating that today, so I thank him for it. Mr. Speaker, I'm following some of my friends in the government side, the members from Eglinton Lawrence and Newmarket Aurora, both lawyers, both capable people and friends. As I've joked before, my friend from Newmarket Aurora was a year behind me in law school, so I'm quite certain he graduated. But you know, I'll leave that to him to talk about. No, I jest. He's very capable, and I know they share our intention here, but their minister has them in a straitjacket, talking about incremental change, agreements on internal trade, Mr. Speaker, that have moved at a snail's pace. In fact, since the war, my friend from Central Okanagan, Similkameen Nicola, has advanced the issue of internal trade more than any government, Mr. Speaker, with the exception of perhaps the 1994 Agreement on Internal Trade, which set up the rubric that we need to expand here today. There has been no recognition of what the origins of Canada wanted to see when this young country started in 1867, which was a free flow of goods and services across this country, Mr. Speaker. And we have not seen that. And I'll remind the members of this House and my friends, the lawyers who were speaking before me, of Section 121 of the Constitution Act 1867, which clearly says all articles of growth, produce, or manufacture of any one of the provinces should be admitted free into each of the other provinces, Mr. Speaker. Unfortunately, early interpretation of this intention seemed to restrict that just to custom duties, so duties charged by provinces between one another. But what built up were walls and silos of legislative and regulatory nature, Mr. Speaker, that effectively limited internal trade within the Dominion of Canada, even though the intention of this country forming was to facilitate that trade. And I'll remind this House, Mr. Speaker, that the early decision of Confederation put Upper Canada, my friends in the Maritimes still refer to Ontario as Upper Canada, put Ontario and Quebec in a more advantageous position by restricting trade with the United States. So in Nova Scotia and New Brunswick, natural north-south trade linkages were stopped by a tariff wall, and in return, there was the build-up of a competitive manufacturing centre in central Canada. So the early decisions to favour some provinces in the Confederation by limiting the north-south trade of other provinces in the Confederation was a policy decision that should have been offset by more interprovincial trade, Mr. Speaker. And we did not see that. And in fact, the Maritime provinces, and later Newfoundland and Labrador, which is an Atlantic province, not a maritime province, had their growth inhibited by the fact that the national policy of Sir John A., whom we on this side love, favoured Ontario and helped build up world-class manufacturing and mercantile trade in those provinces at the sacrifice of the other. But the intention with Section 121 of the Constitution Act 1867 was that Nova Scotia, New Brunswick, Prince Edward Island could trade westward. But what we saw build up was not customs, which were specifically excluded by the courts, but we saw regulatory and other provincial barriers being set up. And what we're doing here today, and what my friend is suggesting by asking for a Supreme Court of Canada reference, Mr. Speaker, which I think is warranted in this case, is we have to, particularly for smaller business in Atlantic Canada and in other parts of rural Canada, Mr. Speaker, we have to speed up the process so that 150 years after Confederation, we can say we barely made it by the 150-year mark in promoting internal trade within Canada at a time that, due to the leadership of the previous government, we were signing record trade agreements with the European Union, with countries in Asia, with the Trans-Pacific Partnership countries, yet we don't even facilitate free trade of goods and services within our own country, Mr. Speaker. So there are two specific legal reasons why I think this Parliament needs to ask the Supreme Court of Canada for a reference. The first is a 2003 Supreme Court case in R.V. Blay, Mr. Speaker, that clearly said that the original intent of legislation is something that a lower court can raise if they believe that there's been a misinterpretation of the original framer's intent. So this is the originalism, original constructionism of our Constitution. And the Supreme Court has said that lower courts are not bound if they feel that the original intention has, and the spirit of that has not been adopted in Canada. And recently, in the province of New Brunswick, the Comeau case, a Superior Court justice took that initiative that the Supreme Court of Canada said is proper in the Blay case to suggest that 121 of the Constitution Act 1867 was not properly interpreted. And in fact, we've had over a century of limited free movement of trade within Canada, not just goods and services, but we've seen Ontario and Quebec for decades struggle over mobility of construction trades and others, Mr. Speaker, when Canada's intent was to facilitate that. The other reason why we should be going to a Supreme Court reference in this case, particularly before we hit our sesquicentennial, is the chain of precedent established in the Bedford and Carter decisions, Mr. Speaker, where in Carter, the Supreme Court of Canada, we've been debating euthanasia-assisted dying in this House. The court said that stare decisis, or precedent, should not be a straitjacket upon subsequent courts. And using the Bedford, the prostitution decision, Mr. Speaker, they said that that precedent could be looked at for two reasons. First, if there was fresh evidence, but second, if there was a change in circumstances. And in fact, in the Carter decision, they looked at the societal change in attitudes with respect to assisted dying between the Sapinka decision of 1993 in the Rodriguez case and Carter. They looked at societal change, Mr. Speaker. And my friend from Okanagan has shown that Canadians want to free their beer. Hear, hear. Canadians want to free their grapes, Mr. Speaker. They want the original spirit of Section 121 of the great experiment that is our Confederation to be realized. So it's up to the government now. We have a justice in the Queen's Bench in New Brunswick who took the leadership of the Supreme Court in the Blay decision in 2003 to say the original interpretation has not been followed. The Gold Seal case, Mr. Speaker, of 1921, dealing with intoxicating liquors being sent to Calgary from outside Alberta in the years of a Temperance Act for Canada, Mr. Speaker. This government is legalizing marijuana. We're way past the Temperance Act days, Mr. Speaker. So the decisions in Bedford and in Carter show when there's societal change and when there's demand by consumers, by producers, to fulfill the potential of the Constitution Act 1867, it's up to this Parliament to act, and it can do so responsibly, allowing the Supreme Court of Canada to use its own precedent to liberalize trade in Canada, Mr. Speaker. I hope we see it before July 1st of next year. Thank you very much.
Questions and comments. The Honourable Parliamentary Secretary to the Government House Leader.
Thank you, Mr. Speaker. You know, a wise man said that negotiations trump litigation all the time. And I say a wise man because it's interesting. The member from Egmont is one of the individuals that ultimately was a signatory to that 1995 agreement, Mr. Speaker, on interprovincial trade. And I believe that he is right when he talks about how important it is when you negotiate in good faith. The difference between the Conservatives and the Liberal government, Mr. Speaker, is the Conservatives want to take it to court, to fight it in the court, and there was always a vacuum in terms of leadership. My question to the member is, will he not acknowledge that, in fact, negotiations is a better way at achieving the type of results that Canadians want, and this is the type of approach that this particular government is taking?
Well, member for Durham.
Mr. Speaker, I thank the member for that question, but it illustrates the problem with the Liberal philosophy. Negotiate, consultations. They are never in a position to make a decision in the long-term interests of the country, Mr. Speaker. They would prefer to debate these things incessantly. We have a window, because of the Comeau decision in New Brunswick, because of case law which is recent in the Carter and Bedford decisions, to move forward quickly on internal trade, the original spirit of Section 121. And I'll remind this House, tomorrow we're going to be celebrating Canadian beer on the Hill, Free My Beer. The original brewers, like that good Conservative Alexander Keith, the Olins family in Moosehead, the only independent, longest-serving brewery in Canada, they were restricted in selling their products, and I know you appreciate Keith, Mr. Speaker, they're restricted to sell their products into prosperous Ontario and Quebec because of misinterpretations of Section 121. It's time for this government to fix it.